In the court, the Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. The first case on today's docket is a rules case, in re amendments to the Florida Rules of Judicial Administration, etc. Mr. Korn.
Thank you, Your Honor. May it please the court. I'm Michael Korn. I chair the Rules of Judicial Administration Committee. As the court is aware, we have allocated between my time and the time of the commenters, and we will try to stick to that as best we can. I know that the court is very much aware of the multi-year process that we have been involved in attempting to take the existing base of rules, which initially moved Florida towards the electronic filing world, and has tried to refine that and improve that process as we move forward. This has been a spirited process. It's been a somewhat long and arduous, and I would be remiss if I didn't thank everyone who had not only participated at our various committees, but the other rule set committees and the commenters who have all given very thoughtful and helpful comments, many of which were ultimately adopted in our response to comments. Some weren't. I suspect they may be some of the subject of today's conversation. This multi-year process really was intended, as I said, to bring us further and further along into what we believe the court's ultimate intention has been for the last decade, which is to move the state of Florida towards as full an e-filing system as we possibly can, while still preserving the rights of pro se litigants and other parties who, for whatever reason, can't utilize an electronic system and must still use paper. We've tried to strike a balance between the interests of the clerks, the interests of the litigants, and most importantly, the interests of the court as it processes this documentation. As the petition states, there are two new rules which we are asking the court's consideration in adopting. Those would be 2.345, which is establishing standards and definitions for what is an electronic signature of a court official, and 2.511, which establishes the e-filing portal. That rule will be the subject of one of the commenters later, and I'll deal with that perhaps on my rebuttal time.
Mr. Korn.
Yes, Your Honor.
Hi, I'm well aware of the work that the committee's put in through this and the other committees, and the comments. Many of them have been well taken by the committee, and there have been suggested changes by the committee in response to many of those. Some the committee rejected, but recognized that they still may have merit and perhaps should be considered by the court. What concerns me is that when the suggested changes came to the Florida Bar Board of Governors, they rejected that, the proposed changes by the committee. And historically, the court has been very reluctant to go past the Board of Governors' view on these rule changes. We've done it before, but we've been very careful about it. And I don't remember it being done in somewhat routine matters that these type of rule changes pertain to. So I have an overriding concern about their rejection, and I'm wondering whether we should just send it back for further consideration to the Rules Committee for further consideration, so perhaps they can gather more common ground among the different committees and approval by the Board of Governors.
Justice Paulson, if I might address your concern. And to do that, I need to take a little step back in time historically. The proposed rules were adopted virtually unanimously by the Board of Governors when they were initially proposed as part of the December 2019 filing. The process that brought us to the October 2020 Board of Governors meeting, and Mr. Lyle is here, who's a member of the Board of Governors. I'm sure he can address your question from his perspective. The Probate Rules Committee, in its own capacity as a Rules Committee, and Mr. Lyle individually, who was an active probate practitioner as well, were concerned about various aspects of the rules which they believed adversely impacted probate practitioners and persons participating in the probate process, specifically dealing with the definitions of filing and signing and how that worked. My perspective, since I made the presentation to the Board of Governors, Justice, was that, and Mr. Lyle can certainly address this, he had recognized that many of the refinements that we made in response to comments not only from probate, but from his own individual comments had been well taken and was appreciative of those. His main concern was that something of a process, he felt somehow that the Board of Governors hadn't been given full information about our process in dealing with the comments. The vote was close. It was, I believe, 18-21 with 3 abstentions. So it was hardly a ringing rejection. And I would suggest that the process issue that I believe governed the decision-making of the Board of Governors in October has to be tempered with the fact that the vast majority, the bulk of these rules were adopted unanimously by the board earlier when they first came up to the court, then subject to publication. So I'm sensitive to what your concern is. We have tried very, very diligently to address the probate rules committee's concerns. Frankly, we're at a point where reasonable people can disagree. And I think that reasonable disagreement was the underpinning of the BOG action.
Mr. Korn, I think Justice Lawson has a question for you.
Yes, sir. I'm sorry. I just wanted to finish my response to
Justice Lawson has a question for you.
Yes, sir.
Thank you, Mr. Korn. Thank you, Chief. I share a similar concern to Justice Polston's, and it goes a little bit deeper in that the concerns that were raised in some areas by former Judge Stevens, Mr. Stevens, and by Mr. Law on the Real Estate Probate and Trust Committee sound very valid to me. And in instances where they're rejected, in almost every instance, the reason given was very vague and did not allow me to understand what the real concern was. For example, with one of them, the response was the proposal implicates substantive areas that the RJAC is not comfortable amending. Well, I mean, that as a decision maker gives me no information on which to judge why you think a proposal for change that seems logical, valid, and reasonable to me should be rejected by the court. So I'm here without enough input, I don't think, to even make a decision on those very important changes that those folks have suggested. And in light of that, would you readdress Justice Polston's question?
Okay. Well, let me try to address your question, your concern as well, Justice Lawson. We felt that we were somewhat hamstrung at the point when we were responding to comments as far as making substantive changes that would then have to have gone back before RJAC for another ruling, especially since we already had a case, a case filing here before this court. We tried very diligently, Justice Lawson, to address these concerns. To the extent that there are refinements that could be made as to some of the rules, we acknowledge that in our response to comments. To use an old cliche, I suppose, our overarching philosophy at this point in time was that the perfect need not be the enemy of the good. We felt that the rule set as it comes as a package to this court is in fact a good, strong, and important refinement that helps the bench, the bar, and all participants in the process. We are committed, the RJAC is committed to continue to work with any of the other rule committees and to continue to refine this. Respectfully, we would suggest that given the history of this, the fact that it was approved by the Board of Governors unanimously back when the case was originally filed, and that the BOG action in October of 2020 was based on what we believe is other considerations, whether it was the strong advocacy of Mr. Lyle, who was very effective in his advocacy that day. We have always been working, Justice Lawson, towards the goal of getting this thing to the court and implemented, knowing that this is going to be an ongoing process, that the rules are always in a subject of evolution. We can put in standards, and RTCT does that for us. Well, we don't necessarily put in technical standards, but there are always changes, evolutions that practice dictates the rules have to take into account. I hope that addresses your question. We tried very hard in the response to be as comprehensive as we could without reinventing the entire rules process, which, as the court knows, has been a multi-year process. As far as Judge Stephen,
with respect to two particular things, I'll take them in order. One, it does seem unreasonable to me to ask an attorney to file something if the filing itself requires certification of things that they wouldn't necessarily know, and it doesn't make sense for them to certify, like that some other party would be the person who's signing the document and certifying. I mean, that seems to be a really reasonable concern, and the response to that didn't, in my mind, address that concern and the problems with the rule as written. So what is the problem with adjusting the language so that the filer of some of these documents that have been addressed isn't certifying accuracy and other things that a signer would generally certify?
This, Justice Lawson, you put your finger on, I think, one of the most contentious issues that has arisen during this process was this concept of the certification of that a party who used their e-credentials to file a document didn't want to be verifying or standing behind an attachment. We, when looking at that concern, tried to draw an analogy to all other areas of practice. It is not, in our view, burdensome, just as we do in a civil case where we're filing insert interrogatories prior to a summary judgment hearing, to file simply notice of filing the answers of John Doe. We don't, as when we file that, we're not certifying that John Doe's answers are correct or that we know anything about them, only that we are certifying that we are doing that. The certification that occurs in that scenario is that the filer certifies that the document that he's filing or she is filing is appropriate and meets all the other technical standards. We don't believe that it verifies the underlying, whether it's an appendix, whether it's an affidavit, or some type of an exhibit. The probate folks have been very insistent and vocal of their concern about that. We have tried very hard to make these rules as uniformly applicable as possible across all areas of practice. So this is, your question is not a new one.
I have a unique perspective. Well, I probably share it with a lot of appellate judges in Florida, including ones on this court. But when you're reviewing an electronic record, and you're looking for the objection from a guardian or something like that that's relevant, and you're looking at the docket, and all you see is, and I've seen it in other contexts on this, is notice of filing, notice of filing, notice of filing. It makes it almost impossible to easily find, or did the last time. And I think about all the extra work that would go into attaching an unnecessary document to something that the law requires to be filed that really is someone else's document. And their concerns make sense to me. And I'm just wondering if there isn't some compromise in the litigation context away from real estate probate and trust, normal civil litigation, business disputes. The notice of filing makes a lot of sense. There aren't a lot of things that are filed, but in the context that we're talking about, it seems like maybe you could accept certain documents, or there ought to be some compromise, because it does seem to me, having reviewed some records with a lot of notices of filing, that having to prepare that extra document and the certification that goes with it and the requirements just would be unduly burdensome and unnecessarily so.
Well, Your Honor, we've always understood that while the rules of judicial administration are intended to be of general application, hence our name change coming up shortly, each particular substantive area can acknowledge in their own special rule sets particular areas. We have tried very hard to make this as uniform and consistent across all lines. We have a philosophical difference with those folks about whether they are certifying that, and Your Honor has just basically identified one of the differences. We did not believe that the act of presenting a notice of filing was that burdensome or non-cost effective to the probate practitioner.
Mr. Court, you need to, you're in your...
Yes, sir, I know that.
almost exhausted your rebuttal time. If you could sum up quickly now, I'm still going to give you 3 minutes rebuttal, but we can't just keep going on.
I understand. And I'm just trying to respond to the court's
I
very
understand.
good
It's not, I fault you not one little bit.
Thank you, Your Honor. When I get back on rebuttal, I will try again to helpfully address some of Mr. Lyle's concerns or some of Mr. McElroy's concerns, especially from the probate side. The comments that were made were thoughtful. We urge the court to consider favorably adoption of this rule with an understanding that RJA will always be in the process of refining it, looking forward to further changes that would be of help to the whole bench and bar. Thank you, Your Honor.
Thank you. Ms. Keating.
May it please the court, I'm Hope Keating on behalf of the Florida Association of Court Clerks. The association filed comments in favor of the proposed amendments to Rule 2.525F that pertains to the docketing by clerks of electronic documents. The association supports the proposed amendments. From the beginning, when the portal was first created and this court first set standards to be used by clerks in implementing electronic filing, there's been a mechanism for dealing with non-compliant documents and a requirement that clerks screen documents and place the non-compliant documents into a queue so that the filer can correct the problem. The proposed amendments do not change the clerk's existing responsibilities in screening documents, but move this function from the technical standards into the rules of procedure and enumerate the reasons that a clerk should not docket a non-compliant document and are an attempt to make the process more uniform. The proposed amendments include procedures for correcting filings up front and in a timely manner. And for these reasons, as set forth more fully in the comments, the Florida Association of Court Clerks urges the court to adopt the proposed amendments to Rule 2.525F.
Ms. Keating, from the clerk's perspective, if we were to require more work on this for more solid common ground to be found, would the courts be concerned about any matters delayed from being adopted in here?
No, Your Honor.
Thank you.
All right. Thank you very much. Ms. Berman.
Good morning. May it please the court. I'm Cece Berman, Chair of the Civil Procedure Rules Committee, here only to mention one discrete point relative to proposed Rule 2.525F2, which is the rule that Ms. Keating was just alluding to. It's on page B26 of your appendix. I've spoken with Chair Korn about this. He mentioned it in his opening. I believe he's going to comment on it favorably in his rebuttal if he has time, which this is a friendly suggestion the Civil Procedure Rules Committee is making today. Ms. Keating just talked about 2.525F2 and how it's the procedure if you file something incorrectly, the parties are notified by the clerk, it goes into a 10-day holding queue, and then at that point, corrective action can be taken. If none is taken, then the document is deemed abandoned and can ultimately be discarded, which is all well and good, except that the proposed rule does not indicate when that clock starts, that 10-day clock starts ticking, whether it's the date of notification to the parties of a problem or whether it is the date of filing. This matters because in our counties around the state, the two dates are not always the same date. Therefore, if this court is inclined to adopt proposed Rule 2.525F2, the Civil Procedure Rules Committee recommends one tweak to the fourth, which is the last sentence of the proposed rule, and that is to add two words, upon notification, to the beginning of the sentence. So it would read, upon notification, the clerk, portal, or other designated facility, and so on. This simple two-word addition would not interrupt the flow of the proposed rule, and it would make clear that the 10-day holding period begins to run from the date of the clerk's notification. Again, this is pointed out in our comments, but this proposed language solution is not. And in preparing for this oral argument, we have spoken with the Rules of Judicial Administration Committee, which again views this proposal favorably. So we would ask that if this court is inclined to adopt the proposed rule, it do so with this minor tweak. If there are no further questions, thank you for your time.
Thank you. Who's next? I have on my list here Mr. Hall, but I don't see Mr. Hall. Okay, whoever goes next, just go.
Morning. May it please the court. My name is Lee McElroy. I'm the current chair of the Florida Probate Rules Committee, and I appreciate this court's time and already discussion. I only have a short amount of time. Obviously, we filed extensive rules with examples of issues we see and tried to convey that there are very specific issues and reasons why we asked for some edits to the proposed rules. We recognize that all courts should move towards electronic filings, but probate is unique. We have non-adversarial use of the court system on a regular basis. We deal with unrepresented parties all the time, and we regularly file documents on behalf of third parties who are simply interested persons in the probate process. Some of those were listed, whether it's a satisfaction by a creditor, whether it's a receipt of a beneficiary, whether it's an appropriate notice from the IRS, or the Agency for Healthcare Administration from the state of Florida. And that goes to some of our concern that we're saying that we are both filers and signers of these documents when we can't actually know that, although in good faith, we believe they are accurate.
Mr. McElroy, does the Probate Rules Committee believe that the rules can be changed in a way so that they can uniformly apply even to probate? Or is it something that's going to have to be carved out separately and the probate rules deal with it individually in some way?
Thank you. No, I think we can solve this issue. And I think that our proposals and working with RJA, we could reach an agreement that maybe not everything, but 90% of these rules can be adjusted to cover everything. And that would be my real hope. And that's what I hope that our commentary to RJA's proposals brings to this court is we want to find a solution, but there are certain things that we think are well taken, like litigants versus parties when everybody is not necessarily adverse. Thank you for your time.
All right, I see Mr. Lyle there.
Thank you, Your Honor. May it please the court. My name is Laird Lyle. My remarks this morning will focus primarily on process. And my request is that you, in fact, decline to adopt the proposals, refer with very specific direction these issues back to the Rules of Judicial Administration Committee. And the specific direction would be to require the committee to address the concerns of the Probate Rules Committee and those concerns raised in my comment. For a review of the process, and let me first comment on Mr. Corrin's observations that these rules, as initially having gone to the Board of Governors, were approved. That to me indicates perhaps a lack of understanding of the process because that was before comments were filed. And so when they went initially, that was before comments. The disapproval or the recommendation to this court to disapprove came after the extensive comments. The committee moved twice for extensions of time. First on June 17, when they informed this court that the comments had yielded some very valuable comments that proposed rule amendments. Again on July 30th, asking for an extension to November 2, indicating to this court that several of the comments are leading to proposed amendments. But the response, which was finally filed on November 11, after yet another extension of time, doesn't have extensive changes, with all due respect to Justice Polston's opening comments, and I'll describe what these very limited changes resulting from the comments are. Appendix D to the response indicates that the subcommittee met 5 times, 3 of those in May, the 15th, the 18th, the 29th, and then not again until July 9th. The final meeting was on either September 18, according to page D1, or September 29, but in any case, the latter half of September. Appendix D at page 46 indicates during the Thursday, July 9 meeting, I was asked to draft a language on this /S/ issue that I believe is a reasonable solution to the probate concern, a solution that I believe gets the court and the clerks where they would like to be, to not have wedding signatures scanned. The minutes reflect that I offered to get a draft to the committee by Monday and that the committee was welcoming the draft language. I actually provided that draft language by noon on Sunday. The subcommittee, and that was after the July 9 meeting, the subcommittee did not meet again, according to the record, until either September 18 or September 29, more than 3 months, nearly 3 months later. And the minutes from that meeting indicate the final meeting of the subcommittee, there is no consideration of the / probate issue, none. The minutes reflect 2 votes occurred, and the minutes are barely 1 page in length. The next meeting was of the full committee. That happened on October 9. Page D55 reflects that the probate liaison to the committee stated that one of Lyle's proposed changes was to expand the / signature in an effort to initiate, she was trying to initiate deliberations at the committee. Chair Korn replied, and I quote from the minutes, "Because the subcommittee did not recommend a change, that issue is not before the committee right now and would not allow discussion on that issue." The minutes from the September subcommittee meeting, the only meeting after the / language was provided, was attended by Chair Korn, and he knew well that there had been no deliberation of that issue at the subcommittee. That brings us to October 23, when the committee presented its report to the Board of Governors. There were 7 changes, and they're very brief in nature. The first is to add a phrase, "and for maintaining a current email address for service of court documents." The second change is to relocate one 3-line provision from one subdivision to another. The third change is to change the phrase "on the date that" to "when." The fourth change is to add "by litigants" to a title. The fifth, to add "service of paper" and deleting the word "issued." The sixth is to change 2020 to the year 2021. And the final is to add the word "scanned." Those were the changes that came after 2 motions for extension of time in which the committee represented to this court that there were valuable comments from with respect to rule amendments that came through the comment process. As noted, the Board of Governors did vote on October 23 to recommend the court not adopt the rules as presented. The rules process, without question, began with rapid fire meetings, 3 meetings in May, a meeting in July that was very substantive, but it fell off dramatically from there. There is no emergency here. There is no rush. And in closing, I would remind this court of your motto: soon enough, if done rightly. Thank you.
All right. Thank you, Mr. Laird. Now, from what I see before me, I assume that Tom Hall and Stephen Stevens have elected not to appear, although they're on the list here as people to appear. So is that, Mr. Korn, is that your understanding?
Chief Justice, they were both on the prep time. I don't know what's happened since 8:30 when everybody had logged on. So I don't know. I can't address that.
Well,
but I'm happy to proceed.
They do not appear to be virtually present.
I understand. I can't.
So in their absence, which
Your Honor, for what it's worth,
I have a note here that says that from Mr. Stevens, I saw something pop up that says he's here, but we need to see you.
There he is.
Okay, I'm sorry, Mr. Stevens, if you've been waiting there and you were not made visible. But I think now's your turn.
Thank you, Chief Justice. Scott Stevens, private citizen, and happy to be here just to answer any questions you may have. As many of you know, I was responsible for this project for the first 5 years, the design and structural aspects of it. And from there, if there's any questions that you have, I don't have anything to say about the current controversy, but I'm happy to answer any questions. If not, I'll yield back my time.
Well, let me ask you this in line with the questions earlier asked by Justice Lawson and Justice Poston. Would you see any harm in delaying any portion of this so that we can send it back and try to reach more of a consensus?
The only concern I have is that I don't think that consensus is ever going to happen. I think that if you really want my suggestion about how to proceed from here, I would recommend, I heard the suggestion made of carving out the probate rules from the filing and service requirements and allowing the rest of it to go forward. It's been a 7-year process so far. I'm a little concerned at the lateness of the concerns raised by the probate committee. These things were not kept secret from the very beginning. They were widely circulated. And I don't know that there's going to really realistically be any chance that the arguments they make are going to be able to be reconciled directly with the rules. I think there's going to ultimately end up having to be a carve out.
All right, thank you.
Thank you.
Mr. Hall.
Good morning. May it please the court. My name is Tom Hall, and I'm here representing myself regarding the individual comment that I filed regarding proposed rule 2.511. My proposal was that the two rules that were in that one rule be separated and moved into part 2 of the rules of judicial administration, which seemed a more proper place for it to be. The committee itself did not feel they could do that based upon some case law from the court saying that that part is reserved to the court. Basically, I think I support moving the mayor. I support the rule as it was proposed in 2.511, but I just think it should be moved to the other part of the rules. And that's it, unless the court has any questions for me.
Mr. Hall, do you share Mr. Stevens' view that this will never be reconciled in a meaningful way? Or do you think that there could be more common ground found?
Well, Mr. Stevens and I usually agree on these sorts of rule things, but this one I would differ with him. I think that we can get there. As part of the process, I was on that subcommittee. Mr. Lyle sent me an email with a really good explanation of what he thought the problem was and some actual practical applications with some real world samples. For the first time, I really truly understood what he was talking about. I think that we ultimately could solve those problems. I know, for example, that I've made a recommendation that electronic signatures be authorized on those documents that have to be signed by other people when our probate lawyer prepares them, for example. I think the one place where I differ is if you file a document in the court, I think an attorney shouldn't be putting it in the file if they don't think it's a legitimate document. I think there's a little bit of disagreement there, but I think it's something that we could work out. I really do. I think it's something that ultimately, if we sit down, we could resolve that, because otherwise probate will operate entirely differently than everything else if we don't resolve that.
Is there anything in the rules that have to be resolved immediately, so that you see that would be somehow damaged by waiting?
Well, I think the other things, the things that don't relate to the probate part need to be resolved. I don't think there's any objection to those, and I think those need to proceed so we can really move into those areas that we're trying to operate in and make sure that we're all operating the same way. So I would, if you're inclined not to adopt, I would not adopt as to the particular things relating to probate, but adopt everything else and let it move forward. I don't think the other things affect that part of it.
Thank you, Mr. Hall. Mr. Korn.
Thank you, Your Honor. Let me just briefly address the two commenters. Ms. Berman is correct. We considered the addition of the words upon notification in 525F2 as friendly and useful, and frankly should have been probably addressed in our response to comments. We think that is an improvement, and it helps not only the litigants, but helps the clerks. Mr. Hall's comment with respect to whether the provisions dealing with the creation of the new rule, 2511, dealing with the establishment of the portal, we believe that really is up to the court. If the court deems that that is not something that should be within the sections of the rule that our committee is responsible for, but is more akin to one of the administrative aspects in Section 2, we respect that, obviously. We were trying as part of this process to give the court the text or the base to deal with the establishment of the portal and how it interacts with the authority. With respect to the other points that were made primarily by Mr. Lyle and Mr. McElroy, we always are willing to try to work this stuff through. This is not an adversarial case in the sense that
Mr. Korn, what do you specifically say about what Mr. Lyle said about when he submitted the particular requested suggestions, and then the minutes don't show any consideration of that? Are the minutes inaccurate?
I'd have to go back and go to them line by line, Chief Justice, but I would say this. The issues that Mr. Lyle very passionately and has consistently raised have been talked about and considered at both the subcommittee level and at the full RJA level for a long period of time. This was not something that came out of left field, certainly. I think that, frankly, the subcommittee that was evaluating the comments had at least reached a philosophical point that this idea of having to file the notice was not the burdensome point that the probate folks feel like it is. I hear and I understand Justice Lawson's comment, which is a very good and sound one, about documents getting lost in a forest of notices of filing. Whether we can look at this and do a carve out, we're always willing to try to work with anybody who is trying to help make these rules work better for the court and for the litigants. Mr. Hall is correct. Not all of the issues that are implicated by some of the objections and comments need to be held up, especially now that we're not on a 3-year cycle. We can bring this to the court at whatever time we can bring it to you as quickly and as expeditiously as possible. We want it done right too. But we also believe that at this point we had reached kind of a point where, as I mentioned before, where reasonable folks could disagree as to the implications of the signer versus filer issue, the issue about whether a /S could be affixed on a non-participating, non-litigant. Those are issues that we had a problem with, just quite frankly. Whether we can address them, if the court directs us to do it, we certainly will do our best. And so for those reasons, and I know I'm now well over Your Honor's charitable additional time, but I would ask the court to, for the reasons expressed, that you consider favorably the rules, if at minimum at least implement the rules that do not implicate the types of concerns that were addressed today. And please understand, we stand ready to be of assistance to the court in any way possible. Thank you, Your Honors.
Well, thank you, Mr. Korn. We thank all the other people who had comments today and who have played a part in this process. And we'll now prepare to go to the second case on today's docket.
Thank you, Your Honor.
The court will now consider the case of the state versus, the case of Spear versus the state of Florida.
Hi, good morning. Glenn Gordon on behalf of the petitioner from the law office of the public defender, Matt Metz. We would actually request 5 minutes for rebuttal as well. There's 2 issues that this court must decide, and the first is whether a trial court has the inherent authority to sua sponte reduce the amount of credit for time served that was over-reported in sentencing documents. And the second question is whether such a reduction in the amount of credit for time served amounts to an increase, sentence increase in violation of the double jeopardy. It is our position that there is no procedural mechanism that permits a trial court to sua sponte reduce the amount of credit for time served, and such a reduction does indeed amount to a sentence increase in violation of double jeopardy. Just to give a brief recitation of the facts before jumping into the issues at heart. In 2018, Mr. Spear proceeded to a resentencing in 2 cases. In 1 case, the trial court awarded 686 days credit for time served, which was applied to each consecutive count. And in the second case, he was awarded 932 days credit for time served. It appears these amounts were calculated by the deputy clerk, and it also included a combination of jail and prison credit. And the trial court never orally pronounced these amounts. So jumping to Mr. Spear appealed, and jumping to sometime during the appeal process in 2018, the Department of Corrections wrote an ex parte letter to the judge to essentially say, hey, please review the credit. There are some discrepancies. On April 2nd, the DCA affirmed the appeal. And then 20 days later, on April 26th, is when the mandate was issued. And on that same day that the mandate was issued, the trial court amended Mr. Spear's credit. So in his first case, the credit was reduced from 686 days down to about 656 days, and also applied to just one count instead of each consecutive count. And then in the second case, it was reduced from 932 days to 632 days. So turning to the first issue, just want to point out a couple of things from the DCA's opinion. It mentioned specifically that Rule 3801 from the Florida Rules of Criminal Procedure only applied to situations that involve the award of too little jail credit. And they essentially held that Rule 3800A was the appropriate vehicle to challenge the incorrect award of prison credit. When you actually look at the plain language of 3800A, it mentions that an illegal sentence, or that a court may at any point in time correct an illegal sentence that was imposed by it, or a miscalculation in the sentencing score sheet when it is affirmatively alleged. So here, counsel is aware of no law that specifically says that the award of too much credit for time served amounts to an illegal sentence. And moreover, the state never affirmatively alleged this error. And in fact, during the sentencing hearing, the state stood idly by when the deputy clerk says, quote, "I don't know math in my head," and then proceeded to give a credit calculation. The only thing that somewhat resembles an affirmative allegation was the ex parte communication by the Department of Corrections that was essentially an end run around the procedural rules, which violated Mr. Spear's due process rights.
Sorry, counsel, I'm sorry to interrupt you. Could I just ask you a substantive question, and maybe this goes more to the second issue that you talked about?
Yes, Judge.
In the sentencing document itself, it seems like it makes the distinction between the sentence, which is the 5 years, and then the special provisions. If we focus on the substance, and I understand what you're saying about the procedural aspect, but if we focus on the substance and what arguably the the defendant here was entitled to, it seems like the sentence, the documents at least, treat the sentence as the 5 years, and then the calculation of the credit time doesn't seem to be the actual sentence or part of the sentence. It's more just sort of an adjustment to the sentence, or it's a way of calculating how we're going to measure the actual time that the person will be there. So could you address that?
Yes, Judge. So I understand the question hopefully appropriately. It appears that both the state and the petitioner, we agree that a decrease in credit necessarily increases the amount of time spent incarceration. It just looks like that main contention lies in how one defines a sentence. So I understand from I believe there was an example from the Gallinet opinion that you're sort of touching on, which was that a judge sentences a defendant to 3 years, regardless of how much time is awarded, the sentence still remains 3 years. And so the question is, well, how does removing credit increase the 3-year sentence? And it is just our position that this is a very extremely narrow view, and it places the sentencing process in a vacuum. It's our position also that a sentence includes the credit as well as the period of incarceration ultimately imposed. For example, anytime that you do not award the credit, that's going to be a double jeopardy violation, because the defendant would essentially be serving more time, or I guess will be twice punished, and the sentence would exceed the maximum if it was not awarded.
Is there how are we supposed to, so I know 921.161 says that the credit, talking about the county credit, the credit must be for a specified period of time and shall be provided for in the sentence, which to me doesn't seem like it necessarily gives a crystal clear answer to this. But how are we, so this issue that that you're talking about, and that's kind of part of my question as to, what is the sentence? I mean, how are we, what source of authority should we be looking to resolve that?
I'm not entirely sure. The one thing is I know that 921.161 does provide the trial court the ability to calculate prison credit as well. And then also just pointing to just the double jeopardy, the clause just mentioning that a defendant has the right to receive credit for time served. I think that those are two of the sources that the court could look at. And I do believe what I am referring to is North Carolina v. Pierce, that mentions that a defendant would be twice punished and his sentence would exceed the max if it was not awarded the credit.
Right. Yeah, but I mean, the right would obviously be to what you actually served. I mean, you don't have a right to the benefit of a clerical error. I mean, it seems like that the procedural issue that you started with, I know, gets to that. But if we focus on the substance, one way of looking at this is just the sort of very basic mechanical question. If you say double jeopardy doesn't allow you to quote unquote increase the sentence, it seems like in order to apply that rule, we need to kind of first decide whether the credit is sort of essentially included in the sentence or whether the sentence is just the 5 years and the credit is just sort of a ministerial thing that, isn't really the actual sentence itself. So how should we, I guess just to come back to the issue of what authority do we look to resolve that?
I am honestly not entirely sure about that specific question, but I could file an amended or I guess a supplemental authority if something does come to mind, but at this juncture, I'm not entirely sure.
Counsel, do you think that there is a difference or should there be a difference when there is a plea that stipulates a set amount of time that's part of perhaps the defendant's consideration in accepting a plea offer that the state has stipulated to jail credit versus this situation where the sentence was what the sentence was and he was entitled to jail credit, period. And so there was no real consideration by the court or the plea process as to that amount. Do you think should be any difference there?
No, Judge, I don't think there should be a difference. Whether the state agrees or not, if the state agrees to more time, it achieves the same end, whether the defendant entered into a plea or everybody knew at the sentencing hearing that, hey, he's going to get X amount of time. I don't think that necessarily makes a difference. And as well, too, I would say that when the trial court places the signature on the sentencing documents, I mean, it essentially ratifies the credit.
But in this case, it wasn't really part of the sentencing hearing. I mean, he didn't have his jail credit time as a consideration. The judge didn't consider it. It didn't appear during the sentencing process. It really wasn't until the very end, as sort of an afterthought. So how would you say that this was part of the sentencing process, other than the fact it was just sort of thrown out there at that very end?
Well, there was discussion during the sentencing hearing. I understand that it was just a clerk making it known to everyone, like, hey, this is the amount of credit that I think the defendant is entitled to. The court was aware of that, as well as the parties, and no one spoke up. I would say that it was part of the sentencing hearing.
Would this whole issue have been avoided if counsels for the state and for the defense just got together, come up with an agreed to calculation of the credit for time served, and have the court basically accept that as the agreed to stipulation as to credit? I mean, I recall when I was a trial judge, I would do that in all my pleas. You take a plea, fine. Both sides stipulate that this is the credit the defendant is entitled to. and that will be it. Would that resolve this?
I think so. Well, yes.
What if later on, when he's back in prison and he starts adding things up, it turns out that perhaps he may have been cheated out of 10 or 15 days in credit. That may seem like a little, but if you're in jail, that's a lot. What if he figures it out later? Is that a way to get around that stipulation, that he can come back later and say, sorry, my lawyer made a mistake?
I think, and that's the reason why it's our position that the defense should probably sit that one out when it comes to agreeing to that, because it does exposes a lawyer to ineffective assistance of counsel. The other part to that as well is I believe that there is at least one case that touched on the court coming back even when the defendant, through no fault of his own, received them a certain amount of credit. The court came back anyways and wound up reducing that. I believe that there is a specific exception for that. But I think just following up on what you mentioned is that it could have made a difference in terms of all the parties being aware of, hey, this is the amount. But then again, I'm not entirely sure, because it seems like that's exactly what happened in this situation. Everyone, the clerk mentioned, hey, this is the amount of time that the defendant is getting. The judge was there, both of the parties. I don't think that, even if the DLC wrote a letter after the fact, I still think the same thing would have happened. Just because
in most cases, it's really not that complicated. The day the defendant's booked and the day the plea takes place, that's usually the case. But here, he had gone to prison, then brought back, and you got all those things mixing, and then you got the clerk just throwing in the prison credit into the pot, and when she mixed that in there, or he mixed that in there, it basically causes discrepancy. So let me ask you this: do you agree that there was a discrepancy here in the calculation of credit for time served to the benefit of your client?
Yes, Judge, I do believe that my client did receive a benefit. And then too, I know that previous justice wanted to focus on the substance, but I do want to point out in Rule 3800B that it does mention that motions may be filed by the state under the subdivision only if the correction of a sentencing error would benefit the defendant. It just seems like I'm aware of no case that necessarily says that, we're going to construe double jeopardy or this particular issue when it comes to credit against the defendant.
But let me ask you this: is there anything that would have kept the state from raising this in an appeal?
I don't think even if they raised it on an appeal, I don't think it would have been meritorious. Just because
Why wouldn't it be meritorious? It's an obvious mistake.
Of course.
Error.
I'm sorry.
It's an obvious error. So obviously their mathematical ability, I guess, wasn't there, or it failed them, and they so and you admit that it's an error. It's a windfall. It's a windfall for your client.
Yes, Judge.
What exclude the state from seeking to correct that error by way of appeal?
Well, it would still need a.
Now, that's not what we got here. I understand.
Okay.
That's not what we've got here. But I'm asking about if the state, because the state didn't appeal, right?
Correct. Yes, Judge. It was just an ex parte letter.
Right. So this is back after the fact. That's the trial court taking it in its own hands. But if the state had appealed, is there anything you know of that would have prevented the state from appealing?
Well, according to the 5th DCA, it mentions that 3800A was the correct avenue, the appropriate vehicle. The state would still have to prove, even if they could go forth with that, they would still have to prove that it was an illegal sentence. And I just don't think that under the circumstances, it would be able to satisfy that. But, I guess to just address the question plainly, probably the state probably could file an appeal.
All right.
Do you have a position on what the right way to fix an error like this is?
Have to quote an old football coach, do it right, do it light, do it wrong, do it long. And under these circumstances, I think that, it's probably best to just defer to the appropriate party to make the calculation before actually having the defendant to rely upon it. I think even previous justice mentioning that it could be all the parties understanding that the defendant is entitled to a certain amount. But
all right, counsel, you're burning up your rebuttal time here.
Yes. So, okay, I think that is all from the petitioner. Thank you, Judge.
All right, thank you, counsel. Hear from the state.
May it please the court, my name is Kaylee Tapman on behalf of the state of Florida. The certified question of great public importance should be answered in the affirmative. The trial court does have the inherent authority to sua sponte amend its sentencing orders to correct the overreporting of jail or prison and jail credit at any time. And this authority comes from its own inherent authority to correct clerical mistakes and scrivener's errors in its own documents. And in this case, the overreporting of the jail credit was a clerical mistake, scrivener's error, where the clerk made a mistake in the reporting of the jail credit. And
Now, wait a minute. Excuse me. That it wasn't just a question of the clerk just writing down the wrong number. The amount of credit to be given was discussed in open court, wasn't it? But there was a conversation between the clerk, the lawyers, and so on in open court. The court accepted the clerk's representation as to what the credit was at the time, and that's what was given.
yes, well, not necessarily. What happened was that the clerk did read originally the correct numbers, the correct number for the jail credit and the correct number for the prison credit, and added them together. And I guess just nobody noticed the discrepancy at that time. The trial court didn't ever repeat the number, and the incorrect numbers made it into the recording of the sentencing document. And then at a later time, when the court was made aware of that scrivener's error, it simply amended it to reflect the sentence that it intended to impose and that was imposed. The sentence that the trial court imposed was 5 years with credit for time served. And the fact that an error was made in the reporting and calculation of the jail credit simply just made it into the documents incorrectly. It was a clerical mistake. It was a scrivener's error, which the trial court had the inherent authority to correct.
Well, and if the state had found this, what was the mechanism available for the state to have this corrected?
The state could have filed a motion under 3800B. The state can file a motion under that rule to correct scrivener's errors. However, it's a very limited time frame. If the state had noticed it, obviously in this case, the state didn't catch the error and nobody caught it for a while. It wasn't
in the A part. Isn't there a provision there for correction when there are affirmative allegations based upon the record?
Yes, there is for prison credit. And I guess jail credit as well.
Was that available then to the state under A?
I believe the state could have done that under A for the prison credit, but here it wasn't necessary because the trial court has the inherent authority to correct its own orders.
Well, what I'm struggling with is in A, the authority is available to the state to bring a motion, and then the trial court upon the motion can make a ruling and make that correction. But where do we find the inherent authority of the trial court to sua sponte do that?
The inherent authority comes essentially from the common law. Every court has inherent powers to do all things that are reasonably necessary for the administration of justice. As far back as 1927, this court has held that clerical errors can be corrected in a court's own documents. And that's what this was. It was simply a clerical mistake. It was a scrivener's error that the trial court was simply amending to reflect the correct sentence in the sentencing documents.
Counsel, what if
when you
go ahead, Justice Grosshans, please.
When you speak of this inherent authority by the court, is there a time limit on that inherent authority?
There is not. There is no time limit. A court has the ability to do this at any time.
So a defendant has 1 year under the rules to bring up the fact that the court may have missed any amount of jail credit. but under your proposed or your view, the court itself could reduce jail credit forever. Has the forever time limit to do that.
Essentially, yes. And the reason is because it's one, a trial court always has the authority to correct its own documents. And in this case, in terms of sentencing, the defendant is entitled to the jail credit for the time he actually spent in jail. And he's simply not entitled to credit for time he didn't spend in jail. And in that sense, I think the trial court has the ability at any time to correct this type of scrivener's error clerical mistake.
Well,
as far as
the
they-
point, but I think you didn't really get the thrust of the question, or maybe I misunderstood. Why should the state get forever to find this and get it fixed when the defendant has the door closed after a year? I don't understand in any universe in which that is equitable. It may be the law, but why would that be possibly fair?
I don't, well, to that I would know that not everything is necessarily fair. And in this case, I would say that, again, he's just not entitled to additional jail credit. If the court is,
Well, the state, but by the same virtue, the state's not entitled to have him serve time that he's already served.
Correct.
But after a year, that ship has sailed. Done.
If the court, I'm sorry, go ahead.
I'm done.
If the court gets an untimely filing from a defendant, could it say I'm invoking my inherent authority to correct this mistake
If it was a clerical mistake, I think it could. And it also, to address Justice Kennedy's concerns, if this court is concerned about such thing, it could always amend the rule to include a time limit for this kind of clarification as well. I would then like to turn to the issue of double jeopardy. And
before you do, though, I have a question that I've been trying to ask. There's a lot seems to hinge on whether the nature of the mistake is clerical. You keep saying that this is a clerical error, a scrivener's error. What if we disagree with you about that? What if we instead conclude that a scrivener's error would have been, for example, that the court pronounced the correct number of jail credit, but the order reduced to writing an erroneous number, an inversion or change of number? That sounds to me like a scrivener's error. What if we disagree with you and say this is not a scrivener's error? This was a substantive error of calculation on the part of the court. Do you still believe that the court retains inherent authority to correct substantive errors in its order, such that if the court used the wrong mandatory minimum or calculated incorrectly the lowest permissible sentence or used the score sheet incorrectly, those too would constantly and forever be amendable by the court? Is that the state's position?
I think what it comes down to is whether the trial court uses discretion in coming up with what the sentence is being imposed. If the trial court is using its discretion and coming up with various calculations, we'll call them, then no, they're not scrivener's errors. In this case, however, it was the clerk who, and it doesn't matter, even if it wasn't a calculation, but she just read the wrong number into the record by reading a wrong file or just simply misspoke. And in that sense, I think it is a clerical mistake. As to other errors, I think it comes down to just how much discretion the trial court used in coming to those decisions. Turning to double jeopardy.
Can I follow up on that though for a second? So if it's not a scrivener's error, then that takes 3.800B off the table as an option.
Yes.
And for 3.800A to be available, it would have to be a quote unquote illegal sentence. So, which I know that that's sort of a complicated thing, but I don't know that this would qualify for that. So what is, if it's not a scrivener's error, then how is it correctable, if at all? other than through this inherent authority?
If it's not a scrivener's error because the court used this discretion, I don't know that it is correctable. I think but on that sense, I think especially when it comes to jail credit, the jail credit is the jail credit. It is what it is. It's not part of the sentence. It's an acknowledgement that the defendant has already spent part of that sentence in detention prior to a sentencing hearing. And so in that sense, when the trial court isn't using discretion or it isn't part of a plea agreement that was agreed to by all the parties, then when the trial court himself isn't magically coming up with this number, it's just a number being read from a file. I think in that sense, that makes it a scrivener's error that can then be corrected through the court's inherent authority to correct its own orders. Turning to double jeopardy, the reduction in jail credit does not increase the sentence because, again, the jail credit is not the sentence is the sentence. And if the defendant is sentenced to 5 years and then some of his erroneous jail credit is taken away, he's never going to serve more than 5 years. In fact, it just makes it so that he will serve the full 5 years. The conflict cases that the Fifth has certified conflict with out of first and second don't really explain why a rescission of jail credit violates double jeopardy other than.
I mean, if a defendant is sentenced to 5 years in prison, I mean, he's got to do 60 months in prison. And prior to that sentence of 60 months in prison, he had served, say, 90 days in the county jail awaiting trial or whatever. And if you take those 90 days away from him, he's doing 5 years and 90 days. So there is a double. Well, I mean, so it is part of the sentence. I mean, so it does make a difference.
Yes, it absolutely does make a difference. And obviously you can never take away the credit that the defendant is entitled to have for the time he actually spent in jail. What we're talking about is taking away an over-reporting of the jail credit to give him additional credit for time that he never spent in prison or jail. And so in that case, that's why it's not increasing the sentence. And the opinion in Gallinat is a well-reasoned, logical opinion that explains why it doesn't violate double jeopardy. And the first reason is that, as we've talked about, it's not a decision that has come from judicial decision making. It's not in this type of scenario where a judge has used his discretion or a part of a plea agreement where the parties all understood and it was actually part of the plea. It's just a number that was recited by the clerk and in this case added incorrectly. The second reason is that it's not a game where one false move creates immunity for the petitioner. The petitioner is not entitled to a get out of jail early card simply because somebody made a mistake or said the wrong number.
Counsel, can I ask you a question on that though? Where do we go to answer the question of whether the sentence is the 5 years or whether the sentence is whatever the number, 5 years, including the calculation of the time?
I think that I don't know what authority necessarily that we would turn to for that, other than to say that, as you noted, the jail credit is in the other provisions document. And I agree that jail credit under, the statute, jail credit must be given. The defendant is entitled.
What is the when the statute says that the credit shall be provided for in the sentence? What does that mean?
I think I believe that it means that a defendant is entitled to receive the credit for the time he has already spent in jail, which is the jail credit. But it's not necessarily part of the sentence when, in the sense that when the trial judge is giving a 5-year sentence, he's intending for the defendant to spend 5 years in prison with the addition of the time prior to the sentencing hearing and the time after the sentencing hearing to create that 5-year sentence. If the defendant is given too much jail credit and a 5-year sentence, he's going to spend less than 5 years. And that is, that's the issue. It's not, it is part of the sentence, but it's not the sentence. The sentence is 5 years. Jail credit is just the acknowledgement the defendant has already spent part of that 5 years in detention prior to the sentencing hearing. Going to the legitimate expectations of finality, in sentencing hearing, a defendant only has the expectation that he will serve his full sentence and be entitled to the jail credit that he is entitled to. He is not entitled to a windfall. And the U.S. Supreme Court and DeFrancesco has said that double jeopardy doesn't require that a sentence be given a degree of finality that prevents its later increase. It's different from an acquittal. An acquittal, the state can't appeal. The state can appeal an illegal sentence, or and if the state succeeds, the sentence can be increased. It doesn't necessarily mean a violation of double jeopardy. And the last reason is that a judicial rule that shortens a legal sentence thwarts society's interest in extracting a full and fair punishment. It's unfair to society that this defendant received additional credit for time he didn't actually serve. If there are no questions.
I actually have a question.
Yes.
Going back to the Scrivener's error. If we agree with you that this was a Scrivener's error, am I correct in understanding that it would have been correctable under 3800B?
Yes.
Okay, so that would have either been on a motion before appeal or motion pending appeal?
Correct.
Okay. Why wouldn't we conclude from that that's when the state needs to do it? And that essentially, although there may be some kind of inherent authority we've talked about in the case law, that we've channeled that and we've limited that here. And we're telling the state, okay, you got a Scrivener's error. You need to fix it now. You need to fix it now. I mean, the whole issue here is, I mean, candidly, is because the state was snoozing on this, right?
Yes, I suppose.
I mean, you get right down to it, the state was snoozing. And there is a cardinal principle of our law that I've mentioned before, and that is the principle that you snooze, you lose in a lot of cases. And I just wonder why, and there are exceptions to that principle, we know. But I wonder why that might not be a principle that should be applied here. I'm sure you will disagree, so I want to give you an opportunity to explain to me why I'm wrong about that.
Yes, Your Honor. And I think it's because it's the duty of the state and the court itself. It's the duty of the court to sentence the petitioner and the defendant. And yes, the state could have filed this motion. It didn't. But that doesn't necessarily matter, simply because it was a clerical error, it was a Scrivener's error, and the court has the authority to correct its errors at any time. The state has less authority to do things at any time. There are time limits on the state, but there aren't necessarily time limits on the court to correct its own orders and documents.
So I just want to understand the inherent authority thing, because obviously if you characterize this as not being something that the state or the defendant is asking for, but that the court is just kind of doing on its own, what are the types of errors that, because obviously that's a way to kind of be an end run around all kinds of procedural rules if the court just says, I'm doing this myself under my inherent authority. So what are the types of things that a court can correct under its inherent authority?
Well,
does it have to be quote unquote clerical, or can they correct substantive errors of their own under their own authority?
No, I don't believe they can correct substantive errors. It's only this very narrow type of error. And especially when this inherent authority, obviously you don't have the authority to do something that's otherwise barred by another rule or statute or other areas of the law. There's only the inherent authority to do all things reasonably necessary for the administration of justice within the scope of your jurisdiction and not in conflict with valid existing laws. And so in this case, it's a very narrow area.
So then that brings you back to the Chief's question of, to the extent that the rule covers how this is supposed to be fixed, then arguably it would conflict with that.
Excuse me?
Well, if the rule provides for this, if the rule addresses this scenario that we're dealing with and tells the world how it's supposed to be fixed, then it seems like it would be an abuse of the inherent authority to do something that the rule actually specifically tells you how to do.
I think that's one way that it could be fixed. But I think when it comes to these kinds of errors or other errors, it's not necessarily just a miscount. It could be a typo in the sentencing document that the trial court sees and it wants to amend. Various clerical scrivener's errors like those, I think the trial court has the authority to do on its own, whereas under 3800B, I believe it requires a motion. And so the trial court has the authority and opportunity to correct its own errors on its own without a motion from either party. Thank you, and we ask that you affirm.
Thank you, counsel. We'll now hear a rebuttal argument.
From the petitioner, I don't believe we have anything further to add, but I am willing to address any questions that the justices may have.
Counsel, do you think the court has inherent authority to award jail time after the 1-year deadline? If a defendant wrote to the judge 2 years later and said, hey, you got this wrong, I actually got this much time, and sure enough, that's confirmed, can the judge award that 2 to 3 years later?
No, and I think that would actually just be fundamentally unfair for a judge to change this just so many years or so much time afterwards. I just imagine a situation.
Even if it benefits the defendant?
Well, if it benefits the defendant, I just believe that the defendant should receive the benefit. But if it's at the state's expense, I just don't think that it's something that the defendant should suffer. I just imagine in a situation where a defendant would be, so much time close, or maybe the defendant actually completed the sentence and, oh, well, hey, we actually made an error with the credit. We're actually going to put you back into prison for just a little bit more, for 3 days more, for 100 days more. I just don't think that would be fair under the circumstances.
Wouldn't amending the rule to require to provide the same 1 year limitation to the state to correct a sentence like this, wouldn't that fix this? I mean, what's good for the goose seems to be good for the gander. And I think the defendant has 1 year, and the state should have 1 year to correct it, instead of your client, let's say he's finished his sentence, and as he's walking out, somebody says, not so fast. You still owe us this 40 days we just figured out from 20 years ago.
Mm-hmm. And I think that would be fair. Something to specifically say, well, yeah, a court does have the inherent ability to correct the error, but under certain circumstances, exceeding the time would abuse that authority. Not sure that I have anything further to add, but I guess are there any other questions that I can address?
All right, counsel, we thank you. We thank opposing counsel as well for your argument in this case today. The court is now going to take a recess of about 10 minutes, and then we'll move on to the third case on our docket.
All right. Thank you all.
The court will now take up the third case on today's docket, Florida versus Mullins. Counsel?
Good morning. May it please the court. My name is Marilyn Becchio. I represent the state of Florida. The state respectfully requests that this court reverse the post-conviction order granting Mr. Mullins a new penalty phase. In finding that counsel was ineffective, the lower court failed to consider counsel's conduct in a context-dependent evaluation as seen by their perspective at the time. And so it's important for this court to understand what it is that counsel actually did. Within 2 weeks of Mr. Mullins being arrested, defense counsel had already gathered all of his juvenile justice records, school records, including various evaluations. Around that same time, they had obtained mental health records from outpatient mental health facilities. They had obtained, or at least tried to obtain, some medical records to substantiate allegations of head injury from 2 different hospitals. Those records either were not available or purged or never existed. They obtained jail records and prison records, including mental health records. They had a mitigation specialist hired. They hired a board-certified clinical and forensic psychologist, Dr. Mackless, who had over 20 years experience by the time he testified at the penalty phase. He interviewed Mr. Mullins 12 times over a 3-year period, wrote numerous reports to defense counsel regarding his opinions in this case. He administered intelligence tests and achievement tests. He explained, I beg your pardon, he reviewed about 3,500 pages of documents that counsel had provided to him before he rendered his opinion. They also hired a neuropsychologist, Dr. Gamache. Early on, Dr. Gamache did a records evaluation for counsel and indicated to Mr. Clapp that the low IQ score found in Mr. Mullins' DOC records was invalid because Mr. Mullins failed to cooperate. This is not something that came as any surprise because there are numerous indications that Mr. Mullins is malingering, that he has factitious disorder, which is a similar but distinct diagnosis. Dr. Gamache also evaluated Mr. Mullins in September of 2011, did a complete forensic evaluation, and at that time notified counsel that he was concerned that Mr. Mullins had a personality disorder that accounted for his outrageous behavior. Nonetheless, at the penalty phase, defense counsel put on evidence regarding Mr. Mullins' mental health, including Dr. Mackless's opinion that he has bipolar disorder and a personality disorder that was not otherwise specified in a substance abuse disorder. Dr. Mackless explained the symptoms that he relied on in reaching that conclusion, which included impulsivity, rule breaking, inappropriate sexual conduct. He also indicated that Mr. Mullins had a low IQ and low achievement scores. He talked about genetic factors in Mr. Mullins' life. He talked about child abuse, including the abuse alleged by the brother, that Mr. Mullins alleged his brother.
Counsel, I'm sorry to interrupt you. Is it the state's position that the exclusion of the head trauma evidence at the penalty phase was a purposeful or strategic choice by counsel?
The decision to not present head trauma was based on the fact that there was no real evidence of head trauma. They tried to substantiate the claims regarding the abuse of Mr. Mullins. They had talked to Wesley Mullins, who was the brother who was the accused in committing these offenses against Mr. Mullins that resulted in head injury, and he denied ever hitting him in the head. So there was really no substantial evidence regarding these head injuries. They did talk about the abuse, though. They talked about the abuse that Mr. Mullins suffered both by his stepfather and by his brother. So there was evidence with regard to those kinds of situations that Mr. Mullins suffered in his upbringing.
Counsel, I'm going to ask, kind of following up on Justice Curiel, with the fetal alcohol syndrome disorder issues, it appears from the evidence that was presented that the attorneys knew of this from more than one source, that there had been some allegations that the mother used alcohol and drugs during pregnancy. The report itself from the Dr. Mackless is completely silent as to that issue. And it appears from the post-conviction record that there was no, the attorneys never followed up on that. They never talked about that. So I guess my question is to you, I understand the case law says, they don't have necessarily the responsibility to oversee the expert, that they can trust their expert. When their expert says, this person doesn't have PTSD, then they're not going to necessarily go back and follow up and check on that. But when the report is silent, when there's nothing, is it within the realm of reasonableness for that attorney to not go to the doctor and say, hey, did this get left out? Do you think this is not valid? Do we need to address that? Because that seemed to be what the trial court was concerned about, is that there was just such a silence. Are we to just presume it wasn't an issue? How would you address that?
Well, it's not just that Dr. Matlis's report was silent about it. It was that there was no other information anywhere else in the record that this was something that counsel knew about. In post-conviction, there was some indication that I believe Ms. Menendier said that she was informed at some point that Mr. Mullins' mom drank while pregnant with her, but Mr. Mullins' mother was alive and well during the pretrial investigation, and there was no indication that she ever told anybody that she drank while pregnant with Mr. Mullins. There was some indication that she drank while he was a child, and that is something that even the post-conviction court says, well, based on the fact that they knew she drank while he was a child, they should have then assumed she drank essentially when she was pregnant with him. So the post-conviction court doesn't even make a finding that counsel actually knew about any drinking on the part of Mrs. Mullins while she was pregnant with Mr. Mullins. And I think it's important to note that she is now deceased, and she was unable, obviously, to come in and confirm whether or not that was in fact true. But there is nothing in the record, anywhere in the record, not in the mitigation specialist notes, not in the doctor reports, not in the attorney reports, that indicate that anyone was ever told that Mrs. Mullins drank while pregnant with Mr. Mullins.
And so counsel, on this, I know, so Justice Grosjean's question on that went to the performance side, but on the prejudice side of that, obviously there's looking at it in, relative to the aggravation, and there's the question of how, qualitatively, how much different this would have been from the other mitigation evidence that was presented. But just on the actual, just focusing just on this one thing, it seemed like the possible relevance of the fetal alcohol issue is that it can cause brain damage. But if ultimately the brain damage wasn't proven in the post-conviction hearing, can you kind of address, it seemed to me that the fetal alcohol thing was just kind of a wash. Even if we thought that there was some ambiguity on the performance side, it seemed like from a prejudice perspective, there really wasn't any proof at the end of the day that it had the consequence that would have made it relevant, different from what was already presented.
Well, that is accurate, that the post-conviction court found that Dr. Wu exceeded the scope of his expertise when talking about damage to the corpus callosum, which was the quote unquote smoking gun that Dr. Mayer used to diagnose fetal alcohol spectrum disorder. And the state's expert came in and testified that Mr. Mullins' brain is completely normal and that there are no deficiencies. And what's important to note here too is, I don't want the court to confuse fetal alcohol syndrome, which is an accepted diagnosis and was an accepted diagnosis at the time, with what they presented in post-conviction, which was fetal alcohol spectrum disorder. Now, fetal alcohol spectrum disorder didn't even come into the DSM until 2013, which was the year that Mr. Mullins was sentenced. It currently, or at least as of 2019, when they had the evidentiary hearing, was in the DSM, but it was still considered an area for further study. So it is difficult to hold either counsel or Dr. Matlis responsible for diagnosing Mr. Mullins with a syndrome that isn't even yet accepted with the DSM. The CDC does state that it should not be, fetal alcohol spectrum disorder should not be considered in a clinical setting. There is still a lot of information that experts don't even have with regard to fetal alcohol spectrum disorder. to this day. So I don't think we could hold counsel or Dr. Magless responsible for not identifying something that the CDC and the DSM don't even have criteria for. And I would note too that all the information that Dr. Mara relied on in reaching this fetal alcohol spectrum disorder diagnosis was accounted for by Dr. Magless's bipolar disorder diagnosis. But for the small corpus callosum, which we have already determined doesn't actually exist. And the post-conviction court found that Dr. Wu's testimony exceeded the scope of his expertise. So when you take that pillar away, you are left with impulsivity, poor decision-making, inappropriate sexual conduct, mood disorders, all of those things that Dr. Mayer attributed to fetal alcohol spectrum disorder, Dr. Magless attributed to bipolar disorder. It is not ineffective assistance of counsel to that post-conviction counsel can obtain an expert who reaches a different conclusion based on the same evidence. It is simply not ineffective assistance of counsel. It is not deficient performance. Counsel in this case gathered a large amount of evidence and documentation with regard to Mr. Mullins' mental health and his upbringing, and presented that evidence to the court. And I would note too that the sentencing court found both statutory mental health mitigators and gave them moderate weight based on Dr. Magless's testimony at the penalty phase. This notion that Dr. Magless was not qualified or was somehow incompetent is not supported even remotely by the record. Dr. Magless, as I said, is a board-certified forensic and clinical psychologist. He had 20 years of experience by the time he testified at this penalty phase. He was hired 3 years before the penalty phase. He wasn't hired weeks before the penalty phase. And as I mentioned, he had direct contact with Mr. Mullins numerous occasions, evaluated him or visited with him and interviewed him at least 12 times. So essentially what happened here is that post-conviction counsel found different experts who reached different conclusions based on the same evidence that counsel had gathered. There was no evidence presented at the post-conviction hearing that counsel did not discover prior to the penalty phase. They did hire Dr. Gamache, who is a neuropsychologist. He did a forensic evaluation of Mr. Mullins. He informed counsel that Mr. Mullins' outrageous behavior was a result of a personality disorder. Opposing counsel hangs their hat a lot on Dr. Gamache's notation that there's a possibility he might have some brain damage. He never recommended any brain scans. He never recommended any neuropsychological testing. The fact that Mr. Mullins might suffer from a personality disorder is also documented in other mental health records that counsel had. There's at least one indication that he might have antisocial personality disorder. The post-conviction experts disagree with that diagnosis. Notably, so did Dr. Magless. He disagreed.
Could you address the statement by the Judge Federico? Did he have a statement in the record?
Judge Federico?
Yes. He was a trial judge and a post-conviction judge, was he not?
Was, yes.
And it was a non-jury penalty phase.
Correct.
So was there a statement that he would have imposed a life sentence had he heard all the mitigating evidence?
There was, Your Honor, and this was the full extent of the prejudice analysis that Judge Federico conducted in the post-conviction. Now, notably, he doesn't review what the significant aggravating factors were in this case. There were multiple homicides. It was committed during the course of a robbery. It was committed at least with regard to Mr. Hayward to avoid arrest. These are very weighty aggravators. He also had a prior felony for an aggravated battery. There was no consideration of those aggravators when Judge Federico concluded that there would have been a difference in the sentencing. And again, Judge Federico essentially accepted the post-conviction presentation of mitigation as opposed to defense counsel's presentation of mitigation. And there was no deficiency in post-conviction and defense counsel's presentation of mitigation. It was just that post-conviction counsel presented it differently, and that is not ineffective assistance of counsel. As
Well,
part of
doesn't that statement provide some evidence that the trial judge could rely upon for sending it back for a new penalty phase?
The prejudice analysis, for what it's worth, no, because you need to have both prongs. You need to have both deficiency and prejudice. And in this case, deficiency wasn't proven. The court did not consider what counsel actually did. The court did not consider what evidence counsel actually put on in mitigation.
I think I may have misheard you earlier in your argument. Did I hear you say that there was no evidence that the lawyers knew about the mom drinking while pregnant?
Correct. There's no evidence in the record, in the attorney notes, in the mitigation notes.
Did the lawyers not concede that?
Ms. Menendiers testified at the post-conviction hearing that she might have heard from other individuals that Mrs. Mullins drank while pregnant with.
I thought the lawyers had conceded that they knew that. Is that not the case?
Well, she did testify that she heard that from other family members. Yes, she didn't testify that she heard that from Mrs. Mullins, and there's no notation in any of these records that that was ever.
Isn't the point that if they knew that, they failed to do further investigation and presentation of that issue? That's the ineffective assistance of counsel?
That is the allegation, yes, Your Honor. But I would point out that there isn't any.
Doesn't that provide some evidence that the trial court could rely upon for sending it back for a new penalty phase? You know, typically we see these in a different ruling posture where the trial court affirmed the denial as opposed to sending it back, and we rely upon our standards of review to affirm those in many instances. Why shouldn't we apply those same standard of review analysis here where it's going back for a new penalty phase?
Because the ultimate determination at the, or the ultimate evidence at the post-conviction evidentiary hearing did not establish that he has fetal alcohol spectrum disorder. And again, I don't know how you can determine that counsel or an expert was deficient for not diagnosing something that didn't actually have the criteria for diagnosis at the time.
In reading Judge Federico's order, he indicated on page 22 that as far back as the fall of 2011, attorney Menadier, is that her name? Is that how you pronounce it? She basically testified at hearing that she had been communicating with Dr. Gamachi, who reviewed the defendant's records and video of crime and conducted forensic evaluation at the jail, and that there was a note also about a conversation with Dr. Gamachi about frontal lobe dysfunctional disorder possibility, and she was aware. She said there was red flags as far as the neurological situations. And then on top of that, she testified that throughout that period, by the way, that was the fall of 2011. This case, the penalty phase took place in 2013. And she testified that during that period of time that she had some personal issues where she suffered with depression for out to about 3 years until the right drugs were administered. And she basically was just not, working on all cylinders. And she missed this at the time. I mean, how is that not something that a post-conviction court can consider in determining whether or not counsel was not deficient?
Well, respectfully, Ms. Menendier's situation is not necessarily completely relevant to whether Mr. Mullins received effective assistance of counsel, because he had more than one attorney. And this was a years-long investigation conducted by counsel. And Ms. Menendier did ultimately present a mitigation case on behalf of her clients. There is no notation that, as I said, that Dr. Gamache ever recommended any kind of brain scan or neuropsychological testing. He doesn't even have a report. The only thing we have is the notation of their conversation that also indicates that he was concerned that Mr. Mullins had a personality disorder that accounted for his outrageous behavior. That's the quote that's in the attorney's note, that he has personality disorder accounting for his outrageous behavior, including wanting to shoot his mother, is what.
Counsel, all of your time, including your rebuttal time, has now been consumed. Because the court consumed a lot of that rebuttal time, I will give you 5 minutes rebuttal anyway.
Thank you, I appreciate it.
But now we're going to give opposing counsel an opportunity.
Thank you, Mr. Chief Justice. Good morning, Your Honors. May it please the court, my name is Stephen Worth and I represent Gaddafi Mullins. Your Honors, Mr. Mullins is a profoundly sick man who suffers from debilitating brain damage and intellectual disability. And sentencing counsel were aware of concrete and uncontroverted facts that put them on notice to investigate further. And they failed to do that at every turn.
So I'm going to go ahead and start with questions. Can you tell me what evidence that was accepted by the trial court was put on at the post-conviction hearing that differed from the evidence put on previously, other than the conclusions of the expert? What actual corroborating sort of evidence of any of these issues was presented at the post-conviction hearing? Absolutely, Justice Grossman, I'd be happy to answer that. So let's start with fetal alcohol spectrum disorder. So there's different forms of evidence that supported this. First of all, there was, for the first time, the court heard detailed evidence that Mullins' mother habitually and almost daily abused drugs and alcohol while pregnant. That was from the stepfather? They heard that from the stepfather, but they also heard that from Ms. Miller and from Ms. Menadier. Two attorneys on his team testified that they knew directly from Cassandra Washington, who at the time of the PCR hearing was deceased, that she drank while pregnant. And I point the court to PCR 1686, where Ms. Miller said, in response to the question, do you have any, or are you aware of Cassandra Washington drinking during her pregnancy with Gaddafi? She answered yes. The question was, how did you learn that? The answer was, she told me. So it's not just Ms. Menadier, it is also Ms. Miller. And then on the following page, Ms. Miller said that the entire trial team was aware of Cassandra Washington's drinking. So you have evidence not only from his father, who witnessed it, you have it from two members of the trial team. The court then also heard expert testimony for the first time of the neuropsychiatric conditions that were likely caused by fetal alcohol spectrum disorder. And you have Dr. Mayer's testimony that Mullins' mother's alcohol and drug use had, quote, an undeniable, clear, and relentless influence on his brain development during gestation. But how is that corroborated? I mean, I understand the expert in this case gave an opinion based on that, and that differed from the expert's opinion at the penalty phase. But we're looking at the ineffective assistance of counsel here, and you had two experts testifying to, quite frankly, very similar behavior at the end of the day. They just had different conclusions essentially on what caused all of this behavior by Mr. Mullins. And so I'm trying to ask, I mean, there's no medical records, there's no diagnoses growing up, there's nothing else other than the testimony that mom drank, and this expert thinks that affected Mr. Mullins that was presented. So I'm just trying to see, is there anything else that I'm missing? Justice President, just to be clear, that is substantial competent evidence that we have neuropsychological diagnoses by experts who examined Mr. Mullins in light of all of, in light of their examinations and also all of their tests that confirmed that he suffers from fetal alcohol spectrum disorder and brain damage as a result.
So counsel, I'm sorry to interrupt you on that. So if we kind of get away from the labels though, because factually the court found that it wasn't persuaded that there was brain damage. And so if you just accept the premise that we take that off the table, and you might disagree with that and you can say why if you want, but if we take brain damage off the table as not proven, then what, and I understand that maybe there was a label that was or wasn't used with the fetal alcohol spectrum disorder, but in terms of the actual behavior or the effects on the defendant that would actually be relevant to mitigation, what's the difference between what you established in, post-conviction versus what was already in front of the court anyway?
Absolutely, Judge Muniz. I understand your question. I'd like to begin simply by addressing this this idea that brain damage wasn't proven, and then I'll address the differences between the evidence. So just beginning.
Can you ask, actually, if you're going to talk about brain damage, though, tell me, instead of just telling me what evidence you put on in terms of it was proven, what did the court find on brain damage?
Absolutely. So the court did find brain damage, and it's based on three different, at least two different bases of evidence. So first, we presented factual evidence identifying potential causes for brain damage, and that would be that Mullins' mother drank heavily while pregnant, and that he suffered serious and repeated head trauma throughout his life. Second, we put on evidence that from two different doctors, Dr. Woe and Dr. Mayer, that Mullins' neuropsychological testing indicated organic brain damage. And to be very clear, this is different from Dr. Wu's brain scan evidence, which, as the court noted, was conflicted with the state's evidence, and he discounted it. But he did not discount the other evidence. He did not discount the evidence from Dr. Woe and Dr. Mayer that, in fact, Mullins' neuropsychological testing, which is not a brain scan, it's a battery of exams that is administered to him in person, did demonstrate very significant brain abnormalities. And this evidence specifically found that he had problems with his frontal limbic system and his frontal lobe. And that's, again, not brain scan evidence. And then there was the brain scan evidence, which the court discounted. The state put on only one witness, Dr. Holder. And Dr. Holder disagreed with Dr. Wu on the brain scan evidence. However, and this I think is really key, Dr. Holder conceded that he would defer to the findings of a qualified neuropsychologist who was administering neuropsychological tests. And that's exactly what we have in this record. We have evidence from our experts of neuropsychological testing confirming that Mr. Mullins suffers from, quote, frontal limbic system and frontal lobe problems. And that's highly, highly relevant to mitigation because those parts...
Sorry, go ahead.
So just to finish my thought, Justice Christens, that evidence is highly relevant because it's these parts of the brain that control judgment, that control rationality, that control social comportment, following rules, reasoning through feelings, impulse control. The expert went through all of this. And to be very clear here, this evidence is different from his other diagnoses. Fetal alcohol spectrum disorder is fundamentally different from other mental illnesses in multiple ways. Unlike Mullins' other disorders, fetal alcohol spectrum disorder is known to diminish the brain's capacity to reason. Unlike other disorders, fetal alcohol spectrum disorder is the single most common cause of intellectual disability. And unlike his other disorders, fetal alcohol spectrum disorder has a known and directly traceable cause. And we can trace it directly to his mother's decision to drink while she was pregnant. So in other words, evidence of fetal alcohol spectrum disorder not only reduces Mullins' culpability, it provides support for his diagnosis of intellectual disability and of organic brain damage. And all of this is relevant to the mitigation analysis. Justice Crossan, did I interrupt you?
No, I interrupted you. How would you, so let's say that we decided to agree that there was ineffective assistance of counsel as to something like the FASD issue. Can you describe how that, in your view, prejudiced the defendant, Mr. Mullins, with respect to weighing the mitigators against the aggravators? I understand what this trial judge said, but I think the standard is, an objective trial judge, given all of the evidence that was presented, how would this sort of evidence have affected the ultimate outcome?
Thank you, Justice Crustens. And I would like to briefly address at the outset here how important it is that Judge Federico was both the sentencing judge and the post-conviction judge. I mean, this is a very rare case where the court knows for certain. This isn't a case where the court needs to speculate as to whether a reasonable judge would change his mind or her mind in the face of this sort of evidence.
But that's not the way this. But that's not the way the standard works, is it? I mean, these are legal questions that we decide as a matter of law based on the record before us. Isn't that correct?
Absolutely, Mr. Chief Justice. This is an objective analysis, but I just want to be very clear here. The best evidence of whether mitigating evidence presented on post-conviction review was reasonably capable of changing a senator's mind is the fact that it did change the senator's mind. But even putting that aside, the weight of the mitigating evidence here that sentencing counsel missed establishes that it absolutely is reasonably probable that some abstract platonic judge would potentially change his or her mind. Counsel's failures here were catastrophic. Counsel failed to uncover evidence that Mullins suffers permanent brain damage caused by his mother's substance abuse, that he failed to identify evidence of intellectual disability, of past childhood sexual abuse, of PTSD. The trial
but
judge—
counsel, when they're looking at these things, even accepting what you're saying is true, they're weighing it against the aggravators. They're weighing it against a surveillance video that showed Mr. Mullins shooting 3 people with no hesitation whatsoever, including, figuring out the gun was not working, pulling someone in, making calculated decisions after a robbery in which he was instructing very clearly on how he thought the actor should be acting. So what I'm trying to figure out is, even let's say the mitigators were present and counsel was ineffective, where exactly does that prejudice come in when looking at this from just that purely legal prejudice question?
So it comes in here because the issues of brain damage and fetal alcohol spectrum disorder, which results in brain damage, it goes fundamentally to the ability of Mr. Mullins to understand the consequences of his actions, to control his impulses, to engage in rational thought, and essentially it goes to the entirety of his culpability. I mean, if his brain is literally broken and he's unable to make rational decisions, then that goes directly to Mr. Mullins's culpability. And I think that's what Judge Federico
Is there any suggestion in the record that he was incompetent to stand trial?
Justice Curiel, there is evidence in the record that he was incompetent to stand trial. We raised this in our counterclaim, specifically related to when he pleaded guilty. We didn't raise a competency to we didn't. So that was the extent of. I'm sorry. Let me be very clear.
I asked the question because it seems to me like what you were saying a minute ago maybe proves a bit much. Don't you agree that if he is incapable of understanding the consequences of his actions, incapable of culpability or in assisting in his defense, it would seem to me that the record before us would contain a bit more on competency. Wouldn't you agree?
I disagree, because we're talking about his ability to control himself in the heat of the moment. We're not talking necessarily about his ability to assist in his defense. And to be clear, there were times when it was absolutely very difficult to work with Mr. Mullins. But it's a different question, Justice Curiel.
Of course it is, but I want to make sure that we're on the same page about how far you're going. It seems to me like Mr. Mullins's position before us today is not that he was wrongly determined to be competent to stand trial. Your position is that he was prejudiced by his counsel's allegedly ineffective failure to identify certain elements of his mental condition, not that he was incompetent to stand trial. Is that right?
Absolutely. That is absolutely correct, Justice Curiel.
So can you talk through, though, in terms of the rule of law that would emerge from what you're asking for? Because obviously at post-conviction, your side did a very effective do-over. There's no question about that. And obviously the trial court was persuaded by that. But if we take a step back and we look at it the way we need to on the front end, and we look at what counsel did here, they had the experts, they had a qualified expert. They appeared to have relied on what the expert said. They effectively presented a lot of mitigation. They persuaded the trial court to find 2 of the statutory mitigators and a bunch of other mitigators. And there's obviously this question about the moms drinking while pregnant, and if you had followed that trail, what you may have discovered through that. But what, in terms of the rule going forward, are we going to have some sort of special rule that if there's evidence of fetal alcohol issues, that's kind of per se an effectiveness not to follow that lead? You have to admit this isn't sort of the easy case where the counsel just doesn't show up and do anything. There was a lot done, and there's one thing that you're focusing on that you're saying had these negative consequences, but what's the rule that we would be articulating going forward?
So I'm not asking for any sort of special rule. This court and the United States Supreme Court have been very clear that fetal alcohol exposure is exceptionally important mitigating evidence, and all you would have to do is confirm that. But just to take a very brief step back here, I know the state listed a bunch of things the trial counsel did. I want to be very clear about just how dysfunctional this sentencing team was. Start with the fact that the team was initially led by Dudley Clapp, the office alcoholic who drank on the job, who was fired for misconduct just 2 months before sentencing. The co-lead attorney, Jill Menadier, was in charge of the mitigation presentation, suffered from chronic depression so severe that she was unable to work during part of that time. She testified that her condition clearly affected her performance in this case, and that her performance was riddled with mistakes. Counsel then failed to hire their only sentencing expert that they actually put on until 8 weeks before sentencing. And despite the fact that that was the only issue at sentencing with mitigation. And Dr. Mackless had never testified in a capital case before. He was given only 8 weeks to prepare, and he was not qualified to diagnose fetal alcohol spectrum disorder or organic brain damage. And I want to be very clear about this. This is not a case where counsel hired an expert and was able to rely on that expert. This is a case where counsel hired an expert who was not qualified to render the key diagnosis.
That's not a finding of the trial court, though. Did the trial court ever make a finding that this doctor was not qualified to testify as an expert?
No, to be clear, Justice Crussens, I'm not saying that Dr. Mackless was not qualified to testify to his expertise. What I'm saying is that fetal alcohol spectrum disorder, key fact that was missed, and organic brain damage, another key fact that was missed, Dr. Mackless did not have the skills or expertise to testify as to either of those. And to be clear, he didn't render an opinion as to either of those. I want to make that very clear, that it's not as if this is a difference of opinion between the experts at sentencing and the experts on PCR review. Dr. Mackless didn't testify as to fetal alcohol spectrum disorder, didn't testify as to organic brain damage. And in fact, his report included material facts that counsel knew to be wrong. And counsel knew that there was evidence that Mullins suffered brain damage. They weren't able to necessarily get hospital records to substantiate that, but there was evidence in the record to support it. And yet, Dr. Mackless said in his report that there's no brain damage, no evidence of no evidence of head trauma. So, this is not a case where you just have a better presentation at PCR review.
Counsel, you're now into your cross rebuttal time.
Thank you, Mr. Chief Justice. I would just like to preserve my ability to address any of the counterclaim issues in my cross rebuttal, and I'll see the rest of my time.
All right, very good. Counsel for the state.
Your Honor, I just want to make very clear that Dr. Mackless was hired in 2010. The sentencing hearing in this case was not until May 13th, 2013. He was not hired 8 weeks before sentencing. There was a previous trial that was scheduled that got continued. He, again, like I said, interviewed Mr. Mullins at least 12 times, wrote numerous reports for counsel's consideration. the significance of the neuropsychological testing that Dr. Wow and Dr. Mayer did depend in large part on the indicators of brain damage that Dr. Wu testified about. They both testified that their conclusions were supported by the evidence of brain damage. They both testified that antisocial personality disorder is often confused with brain damage, and they relied on these reports from Dr. Wu to make the determination that he suffered from fetal alcohol spectrum disorder rather than antisocial personality disorder. So I just want to make sure that the court is aware that this is not an expert who came in at the last minute and was rushed in his determination about his opinions regarding Mr. Mullins' mental health.
Does that help? Does that help you or hurt you?
Well, it helps because Dr. Mathis was the only expert who had this extended course of communication and contact with Mr. Mullins, and who had talked to family members, who read numerous reports. And when he indicates that there's no history of head trauma, that's where he's getting that information from his own interviews, from his own evaluations of reports. So it's not as if he was negligent or unaware of significant information that he needed to have in reaching his conclusion. The allegations of sexual abuse were presented at the penalty phase hearing. Dr. Mathis testified that Mr. Mullins told him that he was sexually abused by his stepfather and that he was abused while in prison. Mr. Mullins' father testified that he had a startle response when you woke him from sleeping, and that his father recognized as something that was indicative of sexual abuse in prison because Mr. Mullins' father had also been in prison. And Dr. Mathis did talk about post-traumatic stress disorder, though he did not diagnose him with post-traumatic stress disorder. He indicated that individuals who are incarcerated while they are teens often show symptoms of post-traumatic stress disorder and associated anxiety. So those weren't things that were not talked about at the penalty phase. They were. Dr. Mathis fully explained his opinions with regard to those. He also talked about low IQ and achievement scores, and that he had other mental illness that could be successfully treated. So he hit all the notes that the post-conviction doctors did. He just had different conclusions with regard to similar symptoms. The one thing that Dr. Mayer testified about with regard to the sexual abuse that he believed proved sexual abuse was Mr. Mullins' act of simulating masturbation while he spoke with Dr. Wow about that. That was fully discussed in post-conviction, in the penalty phase. Dr. Mathis explained that that was a symptom of bipolar mania. It wasn't something that he only did when he was talking about sexual abuse. He did it in the jail. He got in trouble for it in the jail. He told his own counsel that he did it when he was stressed or when he was upset that the commissary didn't have something that he needed. So it wasn't something that he only did when discussing sexual abuse. So that was fully explored as well. And Dr. Mathis testified that that was one of the things he relied on making the diagnosis of bipolar disorder. I will reserve the rest of my time to address the issues that are raised in the cross appeal.
You just had your time.
Oh, I apologize.
Well, am I missing something there?
Well, there is a cross appeal, and I don't believe Mr. Worth addressed the things that were raised on the cross appeal. So if you'd like me to go ahead and preemptively address them now, I will, but I thought that Mr. Worth was going to have additional time to talk about his issues.
Well, he's addressed what he's addressed.
Well, then I will briefly say that with regard to the intellectual disability claim, they weren't raising it as an ineffective assistance of counsel claim. They raised it as a freestanding intellectual disability claim, and that claim was waived when they did not raise it pre-trial as required by Florida law. Additionally, there is record evidence that Mr. Mullins doesn't meet the qualifications for intellectual disability because he has this pre-trial IQ score of 82. He has IQ scores and achievement testing from when he was a teen in the Department of Juvenile Justice that do not indicate that he has any intellectual disability. So right there, he misses 2 prongs of the 3-prong test. So not only was it waived, it was conclusively refuted by the record.
All right, Mr. Worth.
Thank you,
Mr. Worth, could you specifically address the waiver issue?
The waiver of the ID claim.
Yes.
All right. So just very briefly, we've presented good cause for not raising this ID claim until post-conviction proceedings. First of all, because counsel's performance was ineffective, and to be clear,
just to be clear, you did not raise that below, correct? In fact, you said it wasn't due to the ineffectiveness of counsel.
Yes, we did.
Or not you, but whoever was handling it.
Yes, you're right, Justice Crossland. We didn't raise that as a separate ineffectiveness claim, but it is a basis for finding good cause. So that's just sort of a separate analysis. But even beyond that, Florida law at the time precluded him from raising an intellectual disability claim because he didn't have a low enough IQ score. And so even if counsel had been inclined to raise it, they couldn't have at the time. And this, this is the first proceeding at which Mullins was able to present his ID claim under Hall against Florida. But just to take a quick step back, this court need not decide our freestanding intellectual disability claim now. As we explain in our brief, this court can remand for Judge Federico to issue a decision on that claim in the first instance, which is what's required under Rule 3.851. And if this court were to affirm Judge Federico's vacatur of the death penalty on IAC grounds, then we'd be free to raise our ID claim anew at resentencing, at which point we could easily cure any of the potential procedural defects that have been noted. For example, we can notice the claim under Rule 3.203. So we can absolutely cure this, and the court does not need to address the ID claim on the merits.
Well, but I mean, if every supposed basis for good cause that you put forward here is meritless, then aren't we potentially leading the court astray, the lower court, by suggesting that there's still something to look at there? Because none of the things that you've raised are good cause. I mean, you're essentially asking for a retroactive application of Hall. I mean, at the end of the day.
No, absolutely not, Justice Muniz. The Hall was decided while this case was still open. There's
when there was no pending intellectual disability claim.
That's correct. However, if this court were to affirm the vacatur of the sentence, we would be going back on a blank slate, essentially. So all this court would need to do is send the claim back, and we'd be able to notice the claim. We'd be proceeding as if sentencing had never happened, which it hasn't. And then just lastly, with regard to the plea and jury waiver claim, we'll largely rest on our arguments in the briefs. But I just wanted to note here that the counsel failed to uncover evidence that would have shown that he was essentially unable to make these types of decisions because he was on extremely powerful antipsychotic medications. So counsel's failure to uncover that evidence and to adequately advise Mullins about the rights he was forfeiting was constitutionally deficient. But for these reasons,
all right, counsel, you're over time here, so you need to sum up in about 15 seconds.
Absolutely. Thank you, Mr. Chief Justice. For all the reasons in our brief and stated before, I ask the court to affirm Judge Federico's vacatur of the death sentence on IAC grounds and otherwise reverse the decision below with respect to the counterclaims. I thank the court for its indulgence.
We thank both of you for your arguments today.
Thank you.
And the court will now prepare to take up our final case. The court now takes up the case of Morgan versus the state.
May it please the court, my name is Maureen Serber, and I'm here on behalf of petitioner Daryl Morgan. Mr. Morgan was a juvenile when he was convicted of second-degree murder in 1979 and sentenced to life with the possibility of parole after 25 years. After the case of Miller versus Alabama and Atwell, Mr. Morgan filed a 3800A motion to correct an illegal sentence at the trial court. And the trial court granted the motion based on the current case law at the time and set it for resentencing. But time went on, and before resentencing, this court issued the opinion of Michelle, which explained that juveniles in the same posture as Mr. Morgan were not entitled to resentencing at that point any longer. So based on this Michelle ruling, the state moved for the trial court to reconsider its order granting resentencing. And the trial court actually did reconsider and denied Mr. Morgan relief. So the issue in this case is whether the order granting the 3800A was a final appealable order, or whether it is a non-final interlocutory order. And we would submit that it's a final order.
But isn't it your position that it's a final non-appealable order?
Well, it is not. That's correct. It is non-appealable at that time because the rule does not allow the state to appeal it at that point. That's correct. And
let me ask you about that. Where does the district court derive its authority or obtain its authority to hear final appeals from circuit court decisions?
For the state appeals, Your Honor, or anything. Well, they have for the state to appeal. That has to be under the rule.
What is the source of any jurisdiction for the district court?
Well, if they're within the time limit, for one thing, to appeal. Otherwise, they can't appeal.
I'm
sure
not
if I'm answering your question.
Isn't it in the Constitution?
Yes, absolutely. And the second DCA, the second district in this case, found it to be a non-final order, and that's error because I think this is a post-conviction proceeding, and it's a separate. Well, I think their reasoning, one of their reasons is it's a non-final order because it's a continuation of the original case as a 3800A and not a separate case, which I would submit it is actually a separate case because the post-conviction proceedings are separate from the original prosecution. And some of that authority comes from this court's opinion actually in Taylor, and then also recently in Franklin. Well, Franklin was actually really clear about it.
Counsel, I'll let you go back to what you were going to do, but I just want to raise one thing and then I'll leave you alone. How do you respond to the distinction between an authorization under 3850 to vacate a sentence and the authorization under 3800 A to correct a sentence? That the state seems to rely on that.
Right. Well,
to show that they're somehow different.
Well,
for the purposes of the questions that are before us today.
I would say that they're not different because in order to correct a sentence, most of the time you have to vacate the original sentence. In that sense, they're similar, 3850 and 3800A. And I think it's different if you're in the 3800B world, which I think is more of a continuation of the prosecution. It's things that are going on right before or during appeal. But when you're in 3800A, they can have, they can raise that anytime. This is like a viable motion 40 years later. So,
and I understand that we need, in a perfect world, if it's legally the right thing to do, we would want an answer that, resolved, that could apply beyond this particular case and the idiosyncrasies of it. But I mean, in here, the sentence hasn't been vacated.
That's great.
Really, I mean, really nothing has happened.
Well, there's been an order and the order said he was entitled.
Essentially, all it did was schedule a time to make a decision later. It hasn't vacated anything. It hasn't corrected anything. I mean, it seems like the quintessential thing that could be reconsidered by the court.
But it's still final and can't be reconsidered and can't be revisited. even if it hasn't been changed yet, you can't just go back willy-nilly and say, oh, we haven't done anything, so we can change it at any point. The state, the state has.
I mean, when the sentence gets vacated, then there's no sentence theoretically for a while, right?
That's true.
So here the sentence is in place. I mean,
It is.
What is it? I don't. Can you just kind of explain? I mean, what is it that's been done that you're saying is final that should preclude what happened here?
Yes, the order granting the resentencing. That was the end of the judicial labor on this. That was the finality, and that's how you determine finality. When that's the test, and the test is when the judicial labor has finished for the motion, and that means the judicial labor to resolve the motion, not the judicial labor to resolve everything that might happen as a result of the motion. And this court has held that the criminal proceedings that are different from the post-conviction proceedings are different from the resentencing proceedings. And even if you have an order that is resolving the claim, that's the end of the judicial labor. And then the resentencing that may be ordered as a result of the order is a totally separate and discrete proceeding. So the fact that they are separate, and this is the realization that this court just did in Franklin, the fact that they're separate between the criminal prosecution and the resentencings are separate, that means you can't have a non-final interlocutory order, because the final judgment actually, the order for the post-conviction proceedings constitutes a final judgment. So at that point, you can't revisit it again. So even though his sentence has not been vacated, it's still a final judgment.
Well, what you're saying, and I don't want to put words in your mouth, but I think you're saying that by virtue of the court's order, it is effectively vacated, although words, the kind of magic words that it's vacated were not used. Is that an accurate description of your contention?
That's correct. That's correct, Your Honor. And
but that gets back to the Chief's question though about some of the textual differences between 3850 and 3800A. I mean, arguably, if you just look at the text, what the authority is to correct the sentence, and that hasn't happened.
That's true, but if the courts rule that there's an illegal sentence, then that the order is final. So at that point, the state would have to wait and to appeal only after the resentencing. And
isn't the logic of 3850 though that the 3850, the civil side of it, the quasi-civil, quasi-criminal, is ended when the vacator happens, and then sort of the remedial part goes back to the kind of original criminal side. And this seems like the logic of this rule. And there's sort of an arbitrariness to all this. I get that, but it seems like the logic of this rule is different.
The logic of 3800A?
Yes.
Versus 3850?
Yes.
In substance, it really isn't. And many times, pro se defendants will file a 3800A and they'll be treated as a 3850, and vice versa, 3850 times 3800A. And they do have overlapping claims sometimes, but the 3800A is really a much more narrow, if it's done properly, it's much more narrowly tailored. It's just, what is the sentence legal or not? And at this time, when this judge entered the order, his sentence was illegal and he was entitled to be resentenced.
But even textually, where the rule says that, a court may at any time correct a sentence imposed by it, which suggests that it's sort of a continuation of the same case, whereas the logic of the 3850 is that it's more of a kind of parallel proceeding that's completely separate from what happened before.
I would disagree with that, Your Honor, because I think the fact that he's entitled to get a new sentence, or his sentence would be changing, is a similar result to the 3850. Sometimes, the result is a resentencing, and that is, the order kind of triggers a separate proceeding is necessary. So it's the end of the judicial labor for that order, and then when you get to the resentencing, that's another story. So for this
counsel, could the claims of the sort that were here for kind of a revisitation of these juvenile sentences, based on a change in the law that was there for a while, couldn't those be made under 3850 also?
Can this particular, can Mr. Morgan's claim be made under 3850?
Or could it have?
Yes, I think it could have because of the change in the law.
So
Yes.
what we have to, I mean, it's kind of an anomalous thing because it could be raised under 3850, and then there are going to be different consequences with respect to finality than if it's raised under 3800 potentially. Given because based on the way these different things are structured, and one talks about vacate the judgment being vacated, and the other this talks about correction.
Well, that's true, and that's one of the reasons why it seems a little bit unfair to treat them so differently, because he could have filed under one or the other one under 38.
I would assume that there are some claims like this that were. Would I be wrong in assuming that there are some claims like his claim that were filed under 3850?
Absolutely, there are several. There are a lot. They're all over the map on these. There are several of those cases, and the thing is treating them differently. It really it's almost the same. Almost the same procedure in substance, except even the 3800 is much more streamlined. And it's much more narrower. It's much more narrow of a case where we have an illegal sentence. It's either illegal or it's not. So that's kind of one of the things that this Rogers Court and the Morgan Second DCA case tend to harp on is the fact that the state can't appeal this order, but the state can.
Well, let me ask you this also. For this sort of case, this seems like an odd thing for a simple correction, because it involves kind of if what was contemplated was some kind of extensive hearing and not just a simple correction. Like 3800A is like, we can look at this and say, oh, this is wrong, it should be this. And whereas under the circumstance of the sort of claim here, that's not at all what would happen, right?
Well, that's true, except for the beginning. The initial thing is, yes, he does have an illegal sentence because Atwell was controlling, and that was a clear-cut thing. So that was the clear answer, and then the result. I mean, the resentencing would have taken a little bit of time, but any sort of a resentencing, if you'd had an unconstitutional statute, you would have had a resentencing. So it's either the sentence is illegal or it isn't, and his sentence was illegal at the time. But it also doesn't seem fair to try to differentiate the 3800A from 3850 when really they're both post-conviction proceedings, that, there's a finality to the order. I also wanted to address the state's conclusion that, if it's a final order, if this court agrees that it's a final order, then res judicata applies. And I'm going to disagree with that because the case of State versus McBride, which is, I believe, cited in the state's brief, actually specifically holds that res judicata is inapplicable, totally inapplicable to 3800A motions. So I wanted to bring that up because no, there isn't res judicata, and therefore no, they can't raise it, can't override it by a manifest injustice argument, and then again, not let him get resentenced. So I thought that was an important thing to bring up. If the court doesn't have any more questions, I'm going to save the rest for rebuttal.
All right.
Thank you.
Very good. Thank you, counsel. Counsel for the state.
Mr. Chief Justice, and may it please the court, I'd like to get straight into why we think that Rule 3800A is different in important respects from the true collateral attack post-conviction rules of 3850 and 51. I'd like to do so in three parts, which I think touch on some of the comments that justices have made. The first will be about the different legal effect of these competing rules. The second is about their different plain text. And the third is about their different historical provenance. So going first,
before you launch into that, counsel, let me go back to the point that we just dwelled on a little bit. Do you disagree that the sort of claim that was made here by Mr. Morgan under 3800A could have in fact been made under 3850?
I think that's correct, Your Honor.
You think it could have been?
If it were timely filed within the 2-year time bar, yes, I think it could have been raised in 3850. The reason we don't think that that's dispositive is because the availability of multiple remedies doesn't change the underlying character of an order granting resentencing under 3000A. Now, this defendant could have brought his claim under 3850, but the choice of vehicle is nevertheless significant.
So would it then be the state's position that in an identical situation under 38, if it had been brought under 3850, the magic words, the sentence is vacated, and then it went off and floated like this one has. In that case, that's over. That's done with. Whereas in this case, because they chose 3800A as the rule to the procedural route they were going to follow, then it's still up for grabs.
Yes, and I'd like to explain why we think that that is and why that is fair, and that's a fair reading of 3000A. So Jackson and Taylor, they established that 3850 and 51 are true post-conviction collateral attacks. And so what you've said in those cases is that those rules create a very specific sort of independent proceeding that is separate from the underlying case. And so in a sense, when you are done with the judicial labor as to those post-conviction motions, that is when you have vacated the sentence, you're done with the post-conviction claim, you are done with that proceeding, you have a final order. And then you return, as a corollary of that, to the underlying criminal case for resentencing. 3800A, and I think this goes to Justice Muniz's point, 3800A operates differently. It doesn't authorize a trial judge to vacate a sentence, it authorizes the correction of a sentence. And that's significant in two ways. The first thing is that correction is different from vacature because it's a two-step process. The first component of correction is that the judge has to identify a legal error, and that's happened here. And there's been an order granting resentencing based on Atwell. But that is not the end of the labor that is involved in correction. Correction, we think, entails a secondary process of imposing a corrected lawful sentence. That's significant because under the petitioner's theory, we know that you have a final order if the labor as to the alleged post-conviction claim is done. But by the plain terms of 3000A, we are not done with the labor as to that motion because there has been no correction yet. We don't have that. All we have is an order granting resentencing. And so what we are saying first and foremost, and I think if you accepted this, you would need to go no further in this case, and it would be a basis for approving the second district's decision. If you agree with us that correction requires a resentencing by its nature, the imposition of a corrected sentence, then we are not done with the labor as to this motion, whether you want to call it post-conviction or whether or not you want to agree with us and call it simply part of the underlying sentencing proceeding. The second thing that I think that distinction between vacating and correcting tells us is that when you are imposing sentence, what you are doing is quintessentially a criminal task for a criminal judge. Vacating a sentence, that historically has been done in civil habeas, that's a little bit different, but when you are actually imposing a sentence, including correcting a sentence, that has to be criminal in nature and therefore must be a part of the underlying criminal case. I think that makes sense of why in structuring the rules of criminal procedure, this court housed 3000A in the part dealing with the sentence, not in the part dealing with post-conviction relief. Because 3000A, because by its nature it involves correcting and imposing sentences, is inherently part of the criminal case and it's part of the sentencing process. So that's an important distinction.
Let me ask you this. Well, do you know, and I don't know the answer to this. I should maybe, but I don't. Do you know if any of our cases refer to resentencings under 3800A as de novo proceedings?
I don't know that you specifically addressed that, but they are de novo in the sense that the cases cited in Taylor were de novo, meaning the judge is not bound by prior considerations. The defendant has the opportunity to offer new evidence, new arguments. It's de novo in that sense. It's not de novo in the sense that it is somehow a separate proceeding entirely from the 3000A motion. And so I would draw that distinction. And again, that follows from the fact that you are correcting and you are not done correcting simply because a judge has granted an order of resentencing. Now, the second point I'd like to talk about is the different plain texts of these two rules. I've already talked about what we think is an intentional decision to use different verbs, correcting versus vacating, but there are other significant plain text distinctions between 3800A and the true collateral attack rules, 3850 and 51. The first and most obvious is what this court itself started with in Jackson, which is that 3850 and 51, by their terms, tell a court how to treat them with respect to finality. They contain a special textual directive saying that they are final orders for purposes of appeal. And I think it's significant that Rule 3000A contains no such directive. I also think it's significant, and Jackson did as well, that those collateral attack rules contain rehearing provisions. They both allow for rehearing within 15 days. We know that rehearing is used to rehear final orders or final judgments. And so that was a strong textual indication that those are true post-conviction collateral attack, they're final judgments, and so rehearing was appropriate. Reconsideration is what applies to 3000A in our view. It doesn't contain any sort of textual directive about rehearings, and that makes sense of what we've said. The last point to distinguish 3000A from the true post-conviction rules is one about history. And so I hope you'll bear with me for a moment. If you were to go back to the 1960s, there were two ways to challenge a criminal sentence. There was, on the one hand, the writ of habeas corpus, which had always been understood to be an independent civil proceeding. Habeas worked in a sort of counterintuitive way. You would actually file your habeas petition in the civil court, not in front of the same judge who presided over the criminal case and imposed sentence. But it was always understood to be a truly separate proceeding. You had the underlying criminal conviction in this case, and you had habeas, which got its own case number, and you did a true collateral attack. So that was the first way to challenge a sentence. The second way to challenge a sentence was actually by a Florida statute, 921.24. And it was worded almost verbatim the same as modern 3000A. It said that a judge could correct at any time a sentence imposed by it. And so to correct your sentence under that statute, you would file your motion to correct in the criminal case in front of the judge who imposed the sentence. And 921, the chapter where that statute was housed, dealt with judgment and sentence. So these are two distinct ways back before the adoption of the criminal rules to challenge a sentence. This court, I think, pointed out in Jackson that, look, 3850 and 51 are true post-conviction rules in the mold of 3850, or in the mold of habeas. Habeas became those rules. And so in a sense, it is fair to continue treating them as true independent proceedings that are separate from the underlying criminal case. When you are done vacating in the post-conviction attack, like as in habeas, you revert back to the underlying criminal case. They are separate. And so, of course, a grant of habeas was always a final judgment in the sense that you have now held in Taylor and Jackson that the grant of 3850 relief is a final judgment. Now, the reason I'm telling you this is because 3000A does not come from habeas. Historically, it comes from 921.24. That's in the committee notes. It uses the identical language, and we thus think that it is fair to treat it in the same way. And understood in that light, you can understand why these operate differently, why one talks in terms of correcting versus vacating, why one is housed in the part of the rules dealing with the sentence and not in the part of the rules dealing with post-conviction relief. So for all those reasons, we think that leads to the conclusion that orders granting resentencing under 3000A are not entered in their own proceeding. They're entered in the underlying criminal case, and they are non-final and subject to reconsideration. If the court has
Counsel, under 3800A, if a resentencing is ordered based on illegality of the sentence, and then the resentencing takes place, is that the order on the order of resentencing, is that up for grabs in the final appeal of the new sentence?
We haven't staked out a position as to that. I think so. Certainly, if you were to hold against us, it would be up for grabs for a number of reasons. I think we would have reasonable arguments that it could be appealed under 9.140C1, but certainly if you were to rule against us, you would be saying that that grant of resentencing was final. That's why it can't be reconsidered. And we then think that section 924.066 sub 2 would most likely apply. It applies to grants of post-conviction relief and we would argue that it would be immediately appealable. Now, we've asked you in footnote 5 of our brief whether you rule for us or against us to consider a rules change that would specifically enumerate in 9.140C, I believe, J, 3000A grants of resentencing. That is another fundamental distinction between 3850-51 and 3000A. We are not specifically given the right to appeal 3000A grants by Rule 9.140. So the only way currently, in the moment that the resentencing is granted, that we could deal with that problem before the cost and expense of resentencing is if we had some right on the part of the judge to reconsider within its inherent authority. So I think that's a significant point that shouldn't be lost, and that underscores why really there's no unfairness here. And certainly to my opposing counsel's point, these do look in terms of the end results like 3850, but they function in an important and different respect in that we can't take an immediate appeal. And so I think it is only fair that the judge be able to reconsider, as in this case, when it turns out the sentence has been lawful all along, and we now know that based on an intervening decision from this court. Now, even to the extent the court disagrees with our view of 3000A grants of resentencing as being non-final, we still think that we should prevail here, and that's because of the manifest injustice exception to res judicata. At most, if you were to hold against us and conclude that this is a final order, then you would have a final order in a post-conviction proceeding. I think that would be your holding. That's the way to get to that holding. And then the question would be, is that res judicata when you return to the underlying criminal case for resentencing? We think the answer is no, for the reasons we've laid out in the brief.
I guess this, maybe I'm missing something here, but it seems like to me, once you get into that de novo proceeding, you're just under whatever current law is. Current law that would apply to that particular sentence,
Yes.
the particular offense. And so all this about manifest injustice, I mean, because you're in the de novo proceeding, you're stuck with whatever current law is. Isn't that true?
I think that would be correct. What I'm saying, Your Honor, is so this harkens back to the point earlier, and I think my friend on the other side was correct to note that there has been no vacature here. The reason that you could not reinstate the conviction in Owen or the vacated sentence in Okafor and Jackson was because there had been a vacature. So you cannot, what this court said was you cannot retroactively reinstate a conviction that doesn't exist or a sentence that doesn't exist, because that defendant is put back in the position of a defendant who's never had a sentence or has never had a conviction. The same's not true here. Effectively, what we were asking this court to do was not to reinstate something that had been vacated, but simply to leave in place something that was still there. And the only barrier to that, if in fact you rule against us on our first argument, would be res judicata, because you would be effectively saying, well, look, there was a final order granting resentencing. Now the judge must go through with the resentencing, even though there's a sentence in place. And we think that that point is significant. And I'll point you to Judge Lagoa's decision for the Third District in Adams, where she made this point that merely granting resentencing under 3000A does not have the effect of vacating a sentence. That sentence is still there. Under our res judicata and manifest injustice arguments, we're just asking the court to leave that in place because it is no longer bound, based on this intervening change in law, to grant a resentencing. I'd like to address any other questions the court may have, but otherwise, I'm happy to cede the floor to opposing counsel. Thank you.
All right, thank you, counsel. Rebuttal.
Yes, Your Honors. I don't really have much to add to rebuttal, except I hate to admit it, but I do agree that if it goes back for a de novo sentencing, they are subject to the same law as the correct law, which is basically puts my client in the same sort of position. But it doesn't mean you can skip the step of saying that he doesn't have a final order. I think you'd have to go all the way through the process. It's a final order, he gets resentenced, and so be it if he gets life with the possibility of parole after 25 years, even though I don't like that. I do agree with that. Other than that, I didn't really have any other points to address. If the court had no questions, well, I'm going to respectfully request that you quash Morgan and find that the order is a final order. Thank you.
All right. We thank you both for your arguments. That is the last case on our docket today and the last case of this week. This session of court is now concluded.